The police accessing call data information in their investigation of the serious crimes featured prominently in both the morning and afternoon sessions of the Klansman gang trial. This afternoon, while the lead investigator was giving evidence, he noted that one of the accused, Fabian Johnson, after being arrested, had requested a phone call and contacted the lone female defendant, Stephanie Christie. The police witness also says Christie was the same female voice on the phone during a previous operation. The policeman says at the time of that operation, the second witness, who was an informant, had secretly opened a phone line while traveling with Christie so the lawmen could keep track of their location. The police witness says when Christie was arrested later, he seized her phone, which was submitted for forensic analysis. However, he says they have not received the call data information from the telecommunications provider, though a request was made. Earlier today, the police witness also detailed that in relation to the particular operation, he could hear the informant and a female voice for about 20 to 25 minutes. Presiding Judge Chief Justice Brian Sykes interjected, asking the prosecution if they had all the recordings consistent with the operation. One of the lead prosecutors responded, "No, my lord." In response, Justice Sykes said, "Clearly there's something I've missed. So how come there's no records? So you didn't ask for the records?" The lead prosecutor responded, saying they're unaware of that. Justice Sykes then inquired of the police witness who were the providers of the phones used by himself and the second witness. The witness said his phone was Digicel and the informant-turned-witness's phone was Lime, now Flow. Justice Sykes then questioned if no one thought to get the call data information. The witness answered, noting that the recordings of the conversation were available but couldn't speak to the call data information. The witness disclosed that there were challenges with the service providers. The Chief Justice, finding it difficult to digest what was being said, then questioned, how can it be difficult to send the records from a service provider regarding serious crimes? The witness said the request was made but couldn't say why the call data information wasn't available. Justice Sykes, puzzled, said, "The only challenge to me must be a technological one because it can't be that they haven't provided the call data information." He again questioned, is it that neither Digicel nor Flow provided call data requested by the police in the context of them investigating a criminal organization? Justice Sykes said, if that's the case, there's something seriously wrong with that. He continued, does the law allow for this? If so, the law needs to be changed. Something has seriously gone wrong here. No man, that can't be. Clearly, I've misunderstood something. Later on, Justice Sykes questioned separately if accessing call data information was an ongoing problem.
Brian Sykes today again raised concerns about the absence of crucial call data information that has not been forthcoming from the nation's two telecommunications providers. In court on Monday, the lead investigator who is in the witness box had said the police requested the call data information from the two local telecommunications providers, but there have been challenges getting the evidence. It's a revelation that riled the presiding judge, Chief Justice Brian Sykes, and also left him puzzled. He questioned why the police would be having difficulties obtaining evidential material in relation to an investigation into serious crimes. As the prosecution continued its examination-in-chief of the witness today, Justice Sykes declared that the prosecution couldn't continue to go on using moral suasion to try to obtain the call data information. He also said the powers of the court through orders during case management should have been used to summon the providers before trial started. Justice Sykes said he and the defense needed to know what will be the outcome regarding the documents. He asked if the prosecution would continue to use moral suasion or use the powers of the court to summon the telecommunications providers. It's at this point, Senior Attorney Lloyd McFarlane, who is representing Andre Blackman Bryan, rose to indicate he had been working with the case roadmap that the prosecution provided, assuming that no call data information would be a part of the case. He argued that at this stage, it'd be unfair to the defense for the prosecution to be dropping this on them. He pleaded with Justice Sykes to draw the line this week in relation to the prosecution adding more material to the case that wasn't previously disclosed during case management. The phone in question is a black Alcatel. Last week, the prosecution attempted to tender the phone into evidence. However, it was instead marked for identification. This after the police witness, who is still giving evidence, was unable to say what was the International Mobile Equipment Identity IMEI number. The witness says he used a dial code to obtain the IMEI number, but in court last week, the phone was not charged. Today, the witness disclosed to Justice Sykes that the court registrar has charged the phone, which would allow him to dial the code and obtain the IMEI number, which is unique to every phone. But the witness and the prosecution hit another hurdle when the phone was turned on. It was discovered that the phone has a password that isn't known to the police witness. According to the witness, who is the lead investigator in the case, the password would have been added by the user, who is the second witness in the trial. In a turn of events, the police witness then uttered that he would be able to identify the unique number as it was also listed on the back of the phone. Justice Sykes probed how the witness suddenly knew the IMEI number was on the back of the phone but never indicated this before. The witness explained that he didn't know previously about the number being on the back of the phone. He further explained that while observing the phone today, he recognized the last 4 digits on the back of the phone, which are the same numbers he noted in his records as the IMEI number. However, Justice Sykes said the witness was still unable to demonstrate that the same number on the back of the phone is identical to the one he'd seen if the dial code was used. Justice Sykes declared that he couldn't move on from this factor and maintained that the phone would remain at this time as a marked exhibit for identification.
Of the examination-in-chief, cross-examination of witness number 7 began. Things got heated in court as the witness claimed that one attorney was being dishonest during her cross-examination on behalf of defendant Michael Whiteley. Whiteley was in custody in 2018, but according to his lawyer, Denise Hinson, had not yet been charged. 8 months later, Whiteley was then picked up by the witness, who was a detective at CTOC, in July 2019. When asked by the lawyer why it took so long to charge her client, the witness replied by saying it was not time for us to be ready for Mr. Whiteley. After being asked to clarify that statement, the witness said that several checks were done before evidence pointed to Whiteley's involvement in gang activity. It was at this time that the witness made his claim of dishonesty, explaining that for Whiteley to be in custody for so long, he would have to be charged and tried before the court. After a gentle reprimand by Chief Justice Sykes, the witness issued an apology to the lawyer before moving on. Attorney Hinson also asked why the second witness, who admitted to being involved in the gang, was not arrested and charged. The police witness said that upon checking several police divisions, the second witness was not named as a suspect in any other matter. As a result, he was not charged. He also said investigations into the Klansman gang are still ongoing, and the second witness is giving information to the police. This caused a stir among the defendants, some calling for the second witness to be arrested and charged, others begrudgingly mumbling that he secured a plea deal. Andre Golding and Michael Whiteley were positively identified by the police witness, who was in court on Thursday. Meanwhile, a document verifying the return of a SIM card used in the undercover operation within the gang was submitted into evidence.
Chief Justice Brian Sykes on Friday questioned the lead investigator in the One Don Klansman gang trial as to why a former gangster, now turned Crown witness, was not considered a suspect and subsequently charged for his involvement in the criminal organization. Justice Sykes wanted to know if it is a policy of the Jamaica Constabulary Force not to charge former gang members once they become state witnesses. Now, the second witness gave evidence suggesting that he was a spotter for the gang, a don, a driver, and a spectator to numerous alleged murders, but he never pulled a trigger.
The detective says he believes that the route taken was the best one to bring down the criminal organization. He says if the former gang member was charged at the time, then he feels he would be less inclined to cooperate with the police.
Asked if the witness will be charged, the lead investigator says he is not likely to face gang-related charges, but may be charged with other crimes. Now, Justice Sykes pointed out that he has presided over at least 3 gang trials and has never seen a former gang member turned witness answer to charges.
Meanwhile, defense attorney Kimani Bridson suggested that the police gang investigation was poorly conducted, noting that the former gang member incriminated himself but was not assigned a lawyer. Alexander Shaw, another member of the defense, questioned the reliability of the application software that was used by the former gang member to secretly record conversations between himself and other alleged gang members. The court learned that the police witness did not know the name of the app that was downloaded by the former gangster.